The Federal Trade Commission and 17 states are suing Amazon, claiming it operates an illegal monopoly. We spoke with the FTC chair, Lina Khan, back in July about whether the size and scope of Amazon posed an economic threat. Here's what she had to say.
So at the FTC, we look very carefully at specific business practices. Are there business practices that are unfair methods of competition, that are enabling dominant firms to maintain their monopolies in illegal ways? Those are the types of practices that we look at. Historically, we've seen that instances in which you have one firm or a very small number of companies controlling access to commerce, to key channels of commerce or communications, that can create a whole set of concerns.
So it sounds like you just described Amazon.
Again, we look at every company on a case-by-case basis, and there's a lot of bipartisan concern about consolidation in digital markets and just the outsized power that companies can have to pick who gets seen or who gets heard.
For more, let's bring in William Kovacic. He was head of the FTC from 2008 to 2009. He's now a global competition professor at the George Washington University Law School. So we'll get to the FTC chair in a second. But first, can you explain why Amazon's behaviors are viewed as a violation of law or a potential violation of law, as opposed to just a business trying to maximize profits in a competitive business environment?
There's no shame under the antitrust laws for achieving great success. The boundary of concern is when your behavior seeks principally to exclude rivals on some basis other than benefit to society, especially in the form of better prices, more innovation, activities that benefit consumers. So the line that you can't cross is to engage in behavior whose chief aim is to destroy competition without providing significant offsetting benefits to consumers.
And do you think essentially Amazon's defense will be the one I claimed, which is it's a hurly-burly world out there and we're just trying to compete? Or is there some other part of the defense you think they'll put forward?
I'd extend your point in one way. It's to say that everything we do provides a better experience for our users. We've gone from a small enterprise in the 1990s that sold books to offering an incomparable array of experiences for our users. We get them good prices, we get them good delivery terms, we get them a wide variety of benefits that they could not have had before. Our practices might not please our rivals, but they certainly do please our users, and that's the whole point of effective competition.
We heard from the FTC chair, Lina Khan, earlier. Her office is now calling Amazon a monopoly. She wrote a famous article before she was FTC chair, essentially saying that Amazon was like the trusts of the Gilded Age. Do you see this action as against Amazon in specific and that's it? Or is it also an effort to redefine the rules of the road in this current marketplace more broadly?
Your second hypothesis is exactly right. This is an effort to transform antitrust law, to bring it back to the egalitarian roots that prevailed for much of the antitrust experience. In the case of the FTC, that experience literally began 109 years ago today. So on this 109th anniversary of the creation of the Federal Trade Commission Act, we see a decided effort to bring antitrust back to a foundation that looked at providing not only good results for consumers, but provided society benefits in the form of lesser concentration and a more egalitarian environment in which smaller enterprises can thrive. And more than any other case that the FTC or the Department of Justice has brought to date, this case is the signature element of the effort to bring about that transformation.
So then my follow-up question, my last question for you is, do the judges know it? In other words, the FTC has taken on Google, Microsoft, Meta in recent years. Are the courts ready to not only the facts of the case, but also kind of take on a new mindset with respect to the role that government needs to play in creating a fair competition?
This is the point of resistance that the government has to overcome. Certainly since the late 1970s, our courts as a whole have adopted a point of view that gives large firms relatively broad freedom to choose tactics that they like, as long as they deliver consumer benefits. And our courts have not taken a nihilist view of antitrust law, but they have taken the view that the government must bear a significant burden and succeed in showing significant actual or likely harm to prevail. This tends to give large firms the benefit of the doubt in these cases, and a key hurdle that the FTC and its chair have to overcome here is a well-developed set of doctrines that tend to err on the side of letting firms play rather than intervening in their affairs.
William Kovacic, former FTC chair and GW Law School professor. Thank you. That was incredibly illuminating. We appreciate it.
Thank you.